Hi, everyone. My name is Sivan Tumarkin, and I'm a co-founding partner and co-managing partner of Samfiru Tumarkin LLP. I am a disability lawyer, LTD lawyer. We deal with LTD, STD, some personal injury, etc. And I want to cover today a few topics which are very, very important for anyone who is in a situation where they either have to apply for short-term disability or long-term disability, or who have applied, are getting it, and perhaps are finding it difficult to transition from STD to LTD, or who've been denied. So any kind of issues that you are experiencing, or you know someone who's experiencing with disability, long-term disability, short-term disability, I'd like to address those. And of course, you can ask your questions and I'll do my best to answer them. If I don't get to you, I will do my best, but if I don't, feel free to email me, contact the firm. The information here is going to show up in terms of our contact information. So let me start off by talking about what is short-term disability and what is long-term disability, and what are the differences between them. Well, short-term disability is essentially what it sounds like, which is a disability payment, income replacement, if you can't work for a short period of time. Typically, it's anywhere from 3-4 months up until about 6 months. That's what most of these kinds of policies allow for. Now, how do you get that if you can't work? Well, if you can't work because of an illness, if you can't work because of an injury, or a combination of these, then you apply for short-term disability if you have that as part of your health benefits plan at work. Some people don't have that. Sometimes you don't have that. And so you would need to apply for EI sick benefits or whatever other provincial plan you have for sickness, which again, usually will cover that period of time. But what happens if you are unable to continue working for the foreseeable future? So, you know that those 4 to 6 months worth of short-term disability payments are going to end, and you're going to need, to go beyond that. You're going to need to have long-term disability. Again, assuming you have that coverage through your work benefits plan, or maybe you have private coverage, you're able to also purchase disability coverage the way you get house insurance, travel insurance, car insurance. You can get disability insurance. You would want to apply for long-term disability while you are still on short-term disability, because you don't want to have a gap in terms of the amount of time that passes when money's coming in or not coming in. Now, people generally think that if you apply for short-term disability and you get accepted, then you should be able to obviously get long-term disability if in fact you're able or you're not able to work. It should almost be automatic, but it's not. The reality is that sometimes you have a different insurance company that insures short-term versus long-term disability. Sometimes you're going for government assistance for sick benefits for the short duration, and then you have to switch and apply to long-term through insurance company. So it's not always a smooth process. Sometimes people get stuck in the middle. Sometimes the insurance company denies the long-term disability claim, even though you were approved for short-term. So it's really important to understand that even though you are still disabled and your doctor still supports you being off work, it's not always smooth sailing from short-term to long-term. But again, we can help you with that, and I can answer questions. And every case is obviously different. Every case, has its own facts, and you need to understand that, in many instances, when the insurance company denies your claim, that's not the end of the road. We can challenge them and we can force them to pay you what you're owed. Now, I'm already getting some questions here, so I just want to address them before I move on. First question here. Can federal government CRA discipline me for allegedly not hitting in-office attendance for 8 months if I had not received prior warning? Well, that's a good question, but it is an employment law question. And of course, we're going to have an employment law Q&A. I'll say that right now to you, on November 13th at 12 p.m. Mountain Time. It's with Haley Auger, one of our very good employment lawyers. Again, Thursday, November 13th at 12 p.m. Mountain Time with Haley Auger. I'm just going to go here. Question from Farah. My boss keeps texting me again, asking for updates, even though I'm on LTD and not cleared to work. Am I required to respond? Again, a bit of an employment question, but I can give you some guidance here. I think you should respond, but you should advise your boss that you are still on LTD, you are still disabled and having difficulty going back to work. If this becomes a problem, if it becomes harassment, if it becomes bullying, if you feel that the boss is crossing over the line, reach out to us. I'll put you in touch with one of our employment lawyers so you can get proper advice in the employment context. I want to make sure that you understand what your rights are. And again, I want to make sure also people here understand that we do employment law and disability law. And while I'm a disability lawyer, we have a lot of lawyers that do employment law, and we have some lawyers that do a mix of both employment law and disability law. So we got you all covered. But for the purposes of this live stream, I want to make sure that we focus on the disability questions. That's my area of expertise. Next question here. My sister has been trying to get coverage after a fibromyalgia diagnosis, but she keeps getting told she doesn't have enough documentation. What you should do? Okay, very, very common for the insurance company to basically drag their feet and say to you, look, there is insufficient medical documentation, or there is no objective medical documentation. They use that term a lot, objective, to support you being on disability. Here's what it boils down to. If you know you're disabled, and again, people ask me, what disability constitutes disability for the purposes of being on long-term disability? The answer is simple. If you're ill, if you're injured, or if it's a combination of both, I don't really care. If your symptoms prevent you from performing the essential tasks of your occupation, then you should qualify for long-term disability coverage. If you have that coverage, if you have that insurance, then the insurance company should approve you. But here's the caveat here. You need to make sure that the people who are treating you, typically your family doctor, a specialist, perhaps if you have one, other treatment providers, maybe you have a physiotherapist, whatever. Whoever's treating you for whatever is ailing you, whatever is preventing you from working, they need to put down on paper that you need time off. That you need to be off work, doing treatments so that you can recover and eventually go back to work. And if the insurance company, after receiving that documentation, those reports, those letters from your doctors, still say that there is insufficient medical documentation, something is wrong here, give me a call, email me. By the way, you should know it costs nothing to speak to me, a member of my team. What we typically do is we ask you to just forward us in confidence whatever documentation you have, your medical documents, if you want, the letter from the insurance company, and we'll tell you very quickly, within 30 seconds or less, if the insurance company is correct or not, if you need to ask for something more from your doctors. But typically, I can tell you, insurance companies, it's a game for them. You have to understand, right? If they can tell you enough times that there's not enough medical documents, you're not disabled, we're not going to pay you. If they say it over and over and over, number one, they're gaslighting you. Number two, they understand that there's a certain proportion of the population that will give up. So if you give up and your claim is worth $500,000, right? I'm just throwing a number out. Imagine if you got 10 individuals like that, that's $5 million they just saved. So don't be one of those people. Again, if you have questions specific to your case, feel free to reach out to us. It won't cost you a dime to chat with us for us to give you the advice you need. But certainly, insurance companies denying claims or dragging their feet and telling you they don't have enough medical documentation or whatever, when they do, is very, very common, unfortunately. Another question here. This is from Reddit, from Sam. I was approved for CPP disability while on the LTD. Now my insurance company says I owe them back pay. Can they really claw that money back? Okay, this is an interesting question. So, and it is important to understand. CPP disability, as in contrast with CPP, right, Canadian Pension Plan, is a government-funded disability program, federal program. Under the majority of long-term disability policies, you actually have an obligation to try and apply for CPP disability if you are on LTD, if you cannot work for a prolonged period of time. If you get approved, typically what happens, you will get a retroactive pay. Typically that's for about a year. And then you're going to start getting monthly payments from CPP disability. The issue is, and this is unfortunate, but it's just the case, is that the insurer, in most instances, is entitled to that money. Why? Because the long-term disability policy typically contains a provision that gives them a credit. It gives them the ability to take that money and use that as a credit against whatever they're paying you. So a simple example here is if they're paying you $2,000 a month for LTD, and you've applied for CPP disability, and you got approved, and now you're getting $1,000 a month from CPP disability, you're not getting $2,000 from LTD and $1,000 from CPPD for $3,000 total. You're still getting $2,000, except the $1,000 from CPPD that you're getting, that's going to reduce whatever your LTD insurer pays you by $1,000. The question here that I have here is what happens if you got that retroactive amount from CPP disability, right, for that 1 year retroactively, and the insurance company wants that money. Well, typically they're entitled to that money. Again, I'd have to look at your specific policy. Maybe there's a way around it, so feel free to contact us, but typically they're entitled to that amount. If you've spent that already, because most people, you're not holding on to this money, you're disabled, you can't work, you need this money to live on, to pay bills, it may be difficult. You may have to work out some kind of an arrangement with the insurance company for a payback. They understand you can't pay back, let's say $10,000, $20,000. They may start reducing your monthly LTD amount by whatever it is that you owe them gradually. So again, very unfortunate. There are sometimes ways that we can help with that. So again, feel free to reach out, but that's the issue with CPP disability. There are benefits to being on CPP disability, by the way. We can get into that later. But to answer your question here, the insurance company is likely entitled to that back pay, that retroactive pay. Okay. I have another question here, which is, what do insurers mean when they talk about malingering? Okay. So insurance companies, as you know, as we all know, don't like to pay. And they use various reasons and excuses, I call them excuses, for why they don't want to pay. One of the most common things that they say, that they throw at you, is they'll say you're lying, you're malingering, you're over, inflating, providing hyperbole with respect to your symptoms. So when they say that you are malingering, what they're saying is really that you are not really as injured or ill as you say you are. You're just basically a crybaby, essentially, and it's not that bad. And really, we're questioning whether or not you really are as disabled as you say you are. I'm not saying I'm saying that. I'm saying this is what insurance companies are thinking. But they use certain verbiage. And one of the verbiage that they use, one of the words that they use is malingering. Okay. And malingering essentially is a shot at your character. That's how I perceive it when somebody says to me, you are malingering, or if they're saying to one of my clients, you're malingering, I see that as a pot shot at my client, saying essentially that my client is not being truthful or is not being as truthful as they can be. So let me now answer in context, what do you do when the insurance company says that you're malingering? Well, your best defense and offense with respect to that is to have your doctors on site with you. I typically see this with types of injuries and illnesses which are, let's call them invisible. Psychological claims, you can see those on an MRI. If you have chronic pains, if you have fibromyalgia, if you have various types of illnesses that you can't necessarily see with imaging, with an ultrasound, with a CT scanner, with an MRI, those kind of invisible type things are, plaguing people every day. If I have back pain, you're not going to see necessarily anything on imaging, but I have back pain. Am I malingering? Am I lying about it? Of course not. So you'd want to go to doctors. You want to make sure your doctors are on site with you and that they are backing you up and that they're saying to the insurance company, no, this person is legitimately unable to work because of so-and-so, because of this injury or this illness or these set of symptoms. And ultimately, if the insurance company comes back and says, we're going to deny your claim or not pay you because we think you are malingering, if your doctors are on site with you, I can tell you right now, we can go after them. Because I don't care what the adjuster thinks. I don't care what the insurance company thinks. I look at it as a lawyer in terms of what would a judge decide here? Would a judge agree with an insurance company here who has no medical expertise? These are adjusters. These are not doctors. Or will they side with your doctors, your treating doctors, treating professionals who know you, who treat you, who are saying, no, this person is in fact suffering from this and that. I can tell you, if I had to bet money on this, if I was a judge, I would bet on the treating doctors, not the insurance companies. But insurance companies don't know that you know that. They assume that if they tell you we're going to deny your claim or we don't believe you because we think you're malingering, they think you're going to go away. And maybe some people do. I am telling you, if you're legitimately unable to work because of an illness or an injury or a combination of both, and you got doctors on your side, you should absolutely not give up on your claim, and we can help you with that. We can help you position it to the insurance company. One of the interesting things is it does happen. I can tell you it happens every day, but it does happen, and it always makes me smile, maybe even laugh. When you have an individual that is repeatedly denied disability benefits by an insurance company, and we deal with all the major insurers across Canada, and we've had situations, it's happened to a few of our lawyers, happened to me, where we've been retained to pursue those benefits from the insurance company, and the individual has been denied multiple times, has appealed the denials, and then denied over and over. And then the insurance company, upon receiving a letter from me or one of my lawyers that says, we've been retained on behalf of this person. We would like your complete file. You insurance company, you have to give us a copy of your file. The response from the insurance company is an alarmingly, we made a mistake. We're going to go back. We're going to look at the file again. And guess what? They come back saying, you know what? We should be paying this individual. In other words, they understand that when we get in the picture, they can't just, pull whatever they think they can over individuals who are disabled, who are struggling, because we know their tricks. We know how they deal with things. Incidentally, some of us on my team, myself included, used to work for insurance companies in the past. So, we understand what they're doing. We understand the game that they're playing. It's not a game for our clients, but it's a game for them, unfortunately. So in any event, if they're telling you you're malingering, if they're telling you that they're not going to pay you, you're disabled, your doctors agree you're disabled, just talk to us. Talk to us. We'll tell you what your options are. And then, we'll present you with a menu of options, and you say, I want to do X, and then we'll help you get it. We'll help you get the money you're owed. Okay. Let's see. Does Sun Life allow buyout for federal employee disability plan if on active claim for 3 years? Okay, this is a question, interestingly, I got actually last week as well on a TV program. The question is this, I think more broadly, can you, instead of being on disability for X amount of years, let's say you're 40 years old, you technically have 25 years to be on disability, assuming you're disabled for life. Can you negotiate a buyout? And typically where I get these kind of questions, I get them in two scenarios. First scenario is when somebody comes to me and says, the insurance company, Sun Life is actually one of the common ones, but there's other ones too. They've offered me a buyout. They've offered me X amount of dollars that they'll pay me right now if I agree to shut down my claim. So that's one type of buyout scenario I see. Another one is when people come to me and say, can I approach the insurance company and ask for a buyout? Two separate scenarios. Let me deal with the first one. When the insurance company comes to you and offers you a buyout, they will never offer you 100 cents on the dollar. They will never offer you, I've never seen even 50 cents on the dollar. Typically, I see 10 to 20, maybe 25 cents on the dollar. The insurance company is not interested in paying you for the remainder of your claim to benefit you. The insurance company is interested in cutting their losses. So they're willing to put some money out to get that piece of paper signed by you that says you're ending your claim. But they're going to pay you a fraction of what you otherwise would be entitled to. So you need to decide whether or not that makes sense for you, whether you're prepared to do so. For some people, it's important to get a whack of cash right now and just be done with it. But you can't revisit that down the road. You can't say it was a mistake. Once you sign the paper, that's it. The question that arises is, okay, they've offered me a buyout. Can I negotiate that? I can tell you that I've tried multiple times. Typically, insurance companies do not negotiate. They have an algorithm that they use on how they come up with the number that they do, and they simply throw that out there to you. Some people accept, some people don't. They'll oftentimes tell you that they'll pay a lawyer to give you advice. So in other words, they'll say, hey, John, we just offered you $100,000. We know your claim is worth $800,000, but maybe you want $100,000 right now to just end your claim, but you're getting that money up front, that $100,000. Go to Sivan right now. We'll pay him $200 to review this offer and to advise you. So they may offer you some money, potentially, to go to a lawyer to get that opinion. So I've seen that happen as well. But typically, to answer the question that I typically get, I have not been able to negotiate with these insurers. They come out with whatever the amount is that they want to pay you. And if you take it, you take it. If you don't, you don't. The other scenario, can you approach the insurance company for a payout? You can, but it's risky. It's risky because if you are on disability and you've been on it, let's say 3, 4, 5 years, however long, and now you go to them and you say, hey, listen, guys, I know you guys technically would have to pay me for the next 10 years, again, throwing a number. How about this? I'm willing to cut my losses and you can cut your losses. And if you pay me for 5 of those 10 years, then I'll sign, the releasing you. If you're the insurance company, if you're the adjuster getting this, the first thing that happens, the first thing you think about is, why is this person so eager to get a big payout right now? Are they actually better? Are they able to go back to work? Maybe they're trying to pull a fast one on the insurance company. I'm not saying that's what's happening. I'm saying that's potentially what you would be triggering if you go to the insurance company. I have seen that happen. And so what happens is you go to the insurance company, you make that offer, and then they are starting to look at your file more closely. Maybe they'll send you to one of their doctors. Maybe they'll send you to other assessors They'll try to figure out whether or not there is something happening here. What triggered you approaching them? So you have to be careful. You have to be careful with the idea of approaching the insurance company for these kinds of payouts, because it could backfire. Okay, another question here. Do they have to only pay your disability until age 65? Very good question. Typically, under most LTD policies, they go to age 65. People have said, well, this is discriminatory. It's not discriminatory because it's a contractual relationship. You can enter into a contract with anyone for almost anything. They are allowed to have a contract that says that they only pay up to a certain age. Now, keep in mind something. Some policies, those are very, very few and far in between, will have very limited timeframes, 5 years, 10 years, 2 years, that kind of thing. But typically, most policies go to age 65. But I've seen also golden policies where they go beyond age 65. Those are important too. So you need to look at your policy. Don't assume automatically that your policy ends at age 65. I would say, in my experience, 95% of them do, but there are still others which are more time limited, and some that are they go beyond age 65. From Rodney here. I was disabled for 6 months, returned to work 2 months ago with direction from the doc under modified duties and time. Hours worked. After a month of doing what I was instructed, wage was cut 33%. Okay. Again, interestingly, we're dealing with an employment law issue here, right? He's saying he was disabled for 6 months, go back to work through modified duties, and then his wage is cut 33%. All right. I'm not an employment lawyer. We've established that I'm a disability lawyer, but I know enough to tell you that this is most likely a constructive dismissal. The employer here is taking a unilateral action that changes the scope, the character of the contract of employment here. So assuming you're not unionized, because if you're unionized, you'd go to your union and have them deal with it. But if you're not, you should be contacting us. I'll put you in touch with one of our employment lawyers who will tell you exactly what your rights are. I can tell you that in my experience, again, maybe you'll get different advice from them, but the employer cannot simply unilaterally cut your wage by 1/3. Sorry, they cannot do that. They can't. In fact, I'll tell you more than this. There may be human rights violations here. Because you are disabled, you are back on modified duties. So reach out to me after the live stream. I'll put you in touch with the right people, the right employment lawyers to help you. Okay. When do you stop trying to appeal a claim with your insurer? It seems like they provide it as a legitimate option, but is it worthwhile? I love this question. It's a fantastic question. Ashley Burrows, thank you. Okay, let's look at it this way. A lot of people play the lottery. I don't play the lottery, but a lot of people do. But when you play the lottery, you're hoping that it's going to work for you, but you understand that the chances of success are very, very low, just statistically. I can tell you that anecdotally, in my experience, it's very similar to these kinds of appeals. What happens is that the insurance company, what they do is they deny your appeal, they deny your claim, and then the denial letter or email, whatever you're getting, has a paragraph or two at the bottom that says, but if you have new documentation, if you have new information, by all means, appeal this, and we will relook, we will re-examine, we'll reopen your case to look at it to see if we can come to a different conclusion. Maybe we can approve you. Very rarely do I see these approvals actually happen. And I suspect the reason is because you are not appealing to a third party. It's not that you are appealing to a judge, a tribunal, none of that. Sometimes those happen, but typically when an insurance company says you can appeal the decision, it's an internal process. You're literally asking the exact same company that denied you in the first place, or the second time, or third time, however many times you appealed, you're re-asking them to reconsider their denial. What is their incentive to approve you? What? These insurance companies they're making money for their shareholders, for their bosses, whoever it is. So, I can tell you, I have spent years asking insurance companies to provide statistics as to how many of these appeals are actually successful. To me, these appeals are, for the most part, useless. I tell people, if you want to appeal, at least speak with us beforehand so we can actually run you through your options. To me, an appeal is not a good option unless it's the only option available, but that's rare. And plus, even if you're going to appeal and you want to appeal, at least we'll give you some feedback as to how we think you can maybe strengthen that appeal, even though I don't put much faith in these appeals. But the question here is it worthwhile? I don't think it's worthwhile to appeal, certainly not before speaking with us. I want to stress something. when I tell people that there are better options than appealing, what I'm referring to is the legal option. Now, people may say, well, okay, you're a lawyer, it's self-serving to you, you won't work. I can tell you, we're very busy. I don't need the extra work. It's nice to be able to help people. So if you need help or you know somebody, trust me, we will help you. Insurance companies know us, they respect us. But I'm not gonna, convince you. I'm not gonna try and force you to sign up with us if you really want to appeal. But the reality is that there is a much powerful option, which is the legal process, a legal claim against the insurance company. If you appeal once, twice, three times, one thing you have to be very careful of is running the limitation period. Under most provinces' laws, Limitation Act laws, you have a time limit of when you can actually engage the legal process, go after the insurance company through the courts, which is what we do. You have typically 2 years from the date of the first denial. There's arguments, it's a case-by-case analysis. Sometimes, we can look at, was this really a denial or not? We don't want to get into these kinds of discussions. The point is, you have 2 years from the date of first denial. If you continue appealing this denial and you've exceeded the 2-year limitation period, the insurance company is going to laugh in your face because they know you can't force them anymore. You can't go after them legally. So what is their incentive now to approve anything? So I tell people, listen, there is a risk here, appealing and appealing and appealing, but even more so, you're just going to get frustrated with the process, and the money's not going to come in. The bills are going to continue piling high. So why do we tell people, listen, if we think you have a case, we'll tell you you have a case. If you don't want to hire us to help you with this case, hire a different lawyer, as long as you do your homework and you know that the lawyer knows what they're doing. You need a lawyer that goes after the insurance company that knows disability law. This is a specific area of law, like family law, real estate law, criminal law. Disability law is a subset. You need to have expertise. You cannot simply, say you do disability law when you handle one or two cases. So it's really, really important to understand appeals, in my opinion, for the most part, are useless. Certainly, I tell people, do not appeal before speaking with us, but there's a much more powerful option, which is the legal claim process. From Lee, what evaluation is done at the 12-month mark if approved initially for 1 year on LTD? So typically, we don't see 1 year, 12 months. Typically, we see 2 years. The 1 year could be a contractual anomaly here that we're talking about, but typically the way it works, if this is what you're referring to, Lee, is the change of definition of totally disabled. To get LTD for the first 2 years of being disabled, you need to demonstrate with the help of your doctors that you are unable to perform the essential tasks of your own occupation. It's called the own occupation test. The switch happens around the 2-year mark, where the insurance company now requires you to not only show that you cannot do your own occupation, but that you cannot do any occupation for which you are suited for by training, education, or experience. So it's a broader test. It's not just your own occupation, it's any occupation for which you're suited for. And typically a lot of people get cut off or denied disability around that 2-year mark or just before, where the insurance company says, yeah, okay, we agree you can't do your occupation, but here's a list of occupations we think you can do, which are, similar to what it is that, you've had experience in or education. And so we see a lot of people getting cut off there. But the reality is the majority of people that come to us, they can't work in another profession at that 2-year mark. And that's why they come to us, because they've been cut off or told that they will be cut off. And again, we will tell you, we'll spend a few minutes on the phone with you, or as long as it takes, really. But really, we just need a few minutes of speaking with you, of reviewing some key documentation, and then telling you if you have a case or not. And if you have a case, let us go after the insurance company. We don't get paid. If we represent you, we don't get paid unless we force the insurance company to pay you. You don't pay anything up front anyways. So it's really important to understand insurance companies, again, are in the business of denying claims. They're in the business of not paying. We're in the business of forcing them to do so. We're in the business of educating you, the public at large, and empowering you so you understand that you have a lot more power than you think you do. These insurance companies, they may look big and mighty and have billions of dollars, but they don't want to spend that money on their lawyers. Trust me, I've worked for them. I know that. They don't. So make sure that you understand what your rights are. We have a few more questions here. I'm not going to get to them at this point, unfortunately, but feel free to reach out to me, to any member of my team. Truly, we'll speak to you for free. We'll review your case for free. If you have any questions, I've been communicating with people for years who've tried to navigate their own claims. Again, I don't charge a thing. I'm happy to give this information. So thank you very much for joining us today. I want to let you know that the next disability Q&A is going to be on Tuesday, November 25th at 10 a.m. Pacific time. But we also have another Q&A, employment law Q&A, that's going to happen November 13th at 12 p.m. Mountain Time with Haley Auger. Again, check our website. There's a lot of information there. And until the next time, I hope you're well. And if you have any questions, please reach out to us. Thank you.